Supreme Court 5-judge constitutional bench opined that auctions may be the best way of maximizing revenue, but revenue maximization may not always be the best way to subserve public good. In keeping with previous Supreme Court decisions, this bench said, Article 14 does not predefine any economic policy as a constitutional mandate. Even the mandate of Article 39B imposes no restrictions on the means adopted to subserve public good.
Could this bench have taken a more activist or more contemporary view of Article 14 and Article 39B given the circumstances that we live in? Mr. Kadam, you want to comment on that?
Vidya, may I ask? May I ask you a question?
Yes, sir, please.
In what way, what would you think would be in a proactive view?
So,
what should they have said?
No.
I want to know.
So, okay, so I'll give you a very layperson view. I'll give you a very layperson view, Mr. Sarabji. Given the situation...
What have done?
Yeah, so look, the economy has changed considerably, let's say, in the last 15-20 years. There was a time in India when the allocation of most natural resources was done through public sector firms. Today, it's being done through private sector firms. There are allegations of these resources being cornered by private sector firms. Could this bench have laid down that in most cases an auction is desirable, an auction is the way to go, and if there is a deviation from an auction, then it has to be very well explained, the rationale has to be very clear. Could that have been the case? It's a question. I'm not saying that it should have been the case. Could that have been the case?
But the Supreme Court has already said, even in this judgment, that auction is still the most attractive and the most preferred method. But it has only answered the question that it's not the only one. And to answer your question, it's not a question of whether the Supreme Court should be more proactive or less proactive. The Supreme Court has to do the right thing in accordance with law, and that's what they've done. Now, one may wish that in a certain case, a certain section of society may want them to go further in a particular direction. Another section may not want. The Supreme Court is there for that purpose, to make sure that the right thing is done, which may be a middle path in a given case.
Okay.
Look, what is the function of the court? The function of the court is judicial review. It is not within the domain of the judiciary to lay down the policy. It is within the exclusive domain of the executive to lay down the policy. Of course, if the policy so framed is such that it is discriminatory, arbitrary, and all those things which have been said, then you can step down. But you are not, but the court can't frame a policy whether it should take an auction route or the allotment route or go by first come first serve. It is left to the wisdom of the executive to lay out the policy. And of course, the majority view is correct when it says that it is not within the domain of the court to lay down the policy, and of course the policy so framed by the executive should be tested at the threshold of the Constitution of India.
Let me bring in Justice Kehar's judgment or opinion rather here, because that seemed to me a slightly more activist opinion. He has taken, sort of into account the politics of the time, the SEG reports and all of that.
Yes, I think Justice Kehar, I think, will satisfy your favorite expression, proactive.
No, well, I'm saying judicial activism. I thought this court played it judicially safe or politically correct or stayed within the boundaries of what courts need to do, as all three of you have eloquently laid out. I was just wondering whether the current circumstances required the court to take a step beyond that. Justice Kehar, to some extent, has done it. What do you make of his views, Mr. Sarabji?
Frankly, if you ask me, theoretical considerations apart, separation of powers and all that, in the present context, in the present climate, I am all for Justice Kehar's extension of the judicial review.
In that case, you're all for what I've been saying, activist, a slightly more activist view of how Article 14...
We have to satisfy you, apart from the court.
Well, Mr. Sarabji is indulging me, but what do you make of this?
What I feel is Justice Kehar has really used the coal illustration as an illustrative kind of example.
But it's incredibly smart.
It is very contemporary.
Yeah,
it is very contemporary.
Use coal in this
the context
day and age,
is,
to use power generation in this day and age in that illustration, and to make the point very clear that when a power plant has not been competitively bid for, and yet that power producer gets an almost free of cost allocation of coal, then that might be considered invalid if examined by way of constitutional principles. I mean,
but
he's going the whole hog.
But he has, to be fair to him, said that this is illustrative.
imaginary illustration.
And an imaginary illustration. He's used the words, this is taking a hypothetical case, and he's kind of couched it in such language just to make sure that he's not dealing with any specific case, but using it to illustrate the point that he's making.
But he's clearly used coal for a purpose,
yes,
sir.
Yes,
he's not used water, he's not used anything else, he used coal.
Maybe,
can I consider
that
this?
Because he was aware of, he was probably conscious of what is being, he says so in the judgment,
yes, of
that
course.
what is happening in the country, we're all conscious of it, and I take judicial notice of what's happening in the country and the coal issue.
So, Justice Khare, do you believe that the Supreme Court did the right thing? This 5-judge bench played it safe, took the only possible path that maintains balance of power, or do you think that they should have played it a slightly more activist role, as Justice Kehar has laid out in his opinion?
I think what the majority view, in fact this is majority opinion is not a judgment, but they have clarified the thing, and they have the advice and the opinion that is given is within the constitutional frame, and I think they have clarified the correct preposition of law.
In that case, does this dilute the argument of the SEG, either in the 2G case or even in the coal case, that there is a notional loss to this country because the auction route was not used? Now the government can respond by saying, listen, but we're not required to use the auction route, and I'm a little worried if it dilutes that case.
I think it does. Of course, it does dilute the SEG's case substantially. But the Supreme Court in the concluding paragraph, couched though it may be with the words beginning with however, has said that even when you don't follow the auction route and you follow an alternative method, you'll have to justify it as non-discriminatory, not violating the mandate of Article 14, that it was necessary in the public interest not to maximize revenue, not to avoid the competitive bidding process. All those things will be tested again.
I may be making the case for more activism, but that clause has already spooked commercial lawyers. The last word goes to them.
If a natural resource is transferred to a private entity for commercial objective, for commercial purposes, then typically the bidding should be the best route. They said that. That is a fair point. They also said that if it is being transferred for social welfare purposes, then the state is free to look at any other consideration. That also is fair. Now look at the real world scenario. Okay. Now when you transfer a coal mine to NTPC, Coal India, or to any private company in India like Birla's, JSW, any company, just think about any company. Now all these companies, what are they doing? They owe certain responsibility to the shareholders of the company, and that is to make profit. That is very clear. These are all companies for commercial objective, including Coal India, including NTPC. They all have commercial objective. But they may also have a social objective. Now what the government has done, what the Supreme Court has done, by saying that when you are transferring a resource to a company for commercial objective, then the bidding is the better way. And then they said that however, if there are socio objective involved, social and welfare objective involved, then let the government decide. Now what is important is most cases both objectives are involved, and therefore it was very important for the Supreme Court to have laid the guidelines.
This principle that whether it is arbitrary or capricious, if the policy is arbitrary or capricious, in your pre-bid conference meeting you would state so with reasons. So supposing any bidder feels that this is whimsical or this is capricious, you will articulate that policy problem at the pre-bid meeting, and the onus will then be on the government or the executive to explain why did they make such a capricious policy. Now if therefore the warning bells will be there therefore to the government or the department which is making the sale of natural resources, that already this challenge is on the mind of one of the bidders. And it is therefore the shift will have already taken place where the onus will be on the government to defend its policy. It can never be the obligation of a private party bidding in a joint venture to take the burden of a government problem.